So, go ahead.
All right.
Right. Thank you for joining us. My name is Brendan, and I work with the City of Alameda Rent Program. My colleague Ryan does as well. And we're going to give a brief overview of the City of Alameda Rent Ordinance and major themes. So, as we get started, just please remember that the rent program does not provide any legal advice for individual situations. We're just going to be going over ordinance regulations and rules. So here's the agenda for tonight. We're going to go over some background and general information about the ordinance, registration requirements, rent increase regulations, terminations of tenancy procedures, some additional regulations, then services, and at the end, if there's time for questions, we'll take them. So the basics. What is it? Well, the City of Alameda Rent Ordinance is legislation that was adopted by City Council. It was originally called Ordinance 3250, and it's been in effect since September of 2019. It regulates rent increases, terminations of tenancy, and buyout agreements. It requires landlords in the City of Alameda to register all rental units, pay an annual program fee, and advise new tenants of their rights. This is the administration of the rental ordinance. The policymakers are, of course, city council. Those are the people who voted on the ordinance. Those are the people who can vote on ordinance changes going forward. For public information and services, the program administrator is uh, the rent program itself, which is under the city attorney's office. Petitions and appeals are heard by independent hearing officers. Those are non-city employees that contract with the city to hear subjective petitions and appeals. Fee payments are also made to the rent program, which is under the city attorney's office. There are about 16,000 units that are subject to some type of rent regulation here in the city of Alameda. They fall into two different types of properties, fully regulated units and partially regulated units. Fully regulated units are exactly what it sounds like. They are subject to everything that's in the ordinance. So both the limits on rent control and or I beg your pardon, the limits on rent increases and the termination of tenancy procedures and rules. Those are fully regulated units are multi-unit properties on one parcel built prior to 1995. Partially regulated units are only partially regulated. They are not subject to rent control, but they are subject to termination of tenancy regulations. Those are multi-unit properties built after 1995, single-family homes, and any permitted accessory dwelling units, privately owned units occupied by a housing choice voucher recipient, and condominiums. Some properties in the city are not subject to the City of Alameda Rent Ordinance at all. They're completely exempt. Those would be commercial units, short-term accommodations of 30 days or less, so something like an Airbnb or VRBO. The primary residence of a landlord who shares kitchen or bath facilities with a tenant. So that means if I own a home in the city of Alameda and I rent one of the bedrooms out to somebody, but we share the kitchen or the bath, that would not be subject to the rental ordinance. Any units that are owned by the housing authority or a nonprofit with a rent regulatory agreement. And there's a few more things like dormitories or religious institutions, but you can find that in the ordinance. They probably don't cover most people's situations. So I had mentioned that it also requires landlords to register. So when does the registration have to be filed? So for fully regulated units, the initial registration of the property was due May 25th of 2020. The annual registration has to be done by August 31st of each year. A change in tenancy, meaning when the new tenant starts, has to be filed within 30 days of the start date of that tenancy. And a change in ownership has to be registered within 30 days of transfer. Those are for fully regulated units. For partially regulated units, the initial registration for a tenant has to be within 30 days of the start days of the tenancy, and a change in ownership is not required but strongly recommended within 30 days of transfer. So you don't want to be getting mail or bills from us if you no longer own the property. So that's why we strongly encourage that folks um, let us know. Annual registration. So this is relatively new. It had always been part of the ordinance, but during COVID, uh, we were not maybe as strict as requiring the annual registration. Now we are. This previous year was the first year that we required it. It will allow the rent program to provide both the tenant and landlords more clear and precise information about exactly how much the landlord can raise the rent. Previously, we had given more broad information because we didn't have all of the information that landlords about landlords' properties. Uh, Based on feedback and just for ease of administrating the ordinance, we now require that landlords complete an annual registration so that we can provide more accurate information to both tenants and landlords. And again, that registration due date is August 31st of each year. The annual cycle. So the rent program, we work on a calendar, a cycle, and some of these dates are fixed. Some of them are have a little bit more um, flexibility. But to give you an idea, here on the screen it shows May 1st is when registration forms will start to be accepted. May 20th is when the annual general adjustment and fees for the upcoming program year are announced. June 1st is when the rent registry opens for online registration and fee payment. July 1st is when physical invoices will be mailed out to any landlords that have not paid the program fees yet. August 1st is the deadline to submit fee exemption requests. August 31st is the deadline to submit the registration that I previously mentioned and pay the annual program fees. September 1st is when the new annual general adjustment goes into effect, and late penalties will start to be assessed on any unpaid program fees. And then come fall, winter, October through February, landlords and tenants are going to get some mailings. Most will receive notification on how much the landlord is permitted to increase the rent under the rent ordinance, with a deadline to contest that determination if either the landlord or tenant thinks that the information is incorrect. So again, we're going to be basing that off the registration information that the landlord provides. We'll also mail out notifications when landlords have failed to submit registration and or pay program fees, and or when registration information indicates an invalid rent increase or some other kind of error, landlords will be given an opportunity to remedy that violation and correct the registry. I'm going to go over some of the terms that was on that previous page. So you heard me say rent registry. That is an online um, portal that we as program administrators use and that both tenants and landlords can use. We strongly recommend that landlords take advantage of the rent registry to register their properties, to update their properties, to keep track of their properties, and to pay their annual program fees. Landlords can confirm the information that's already in the registry. They can update it. They can, anything that you can do via paper form, you can do on the registry, just about. And we did a bunch of clinics last year, and we will be doing them this year as well to assist with any landlords who have questions about how to use the registry, or property managers or tenants. So to create a registry account, Uh, Both tenants and landlords can do it. Landlords have more tools available to them because they have more requirements under the ordinance. So landlords can use the rent registry to pay their annual program fee by credit card. They can report a new tenancy, a change in ownership. They can file no-fault terminations of tenancy. They can request an exemption. They can request a staff review. They can file a petition, and they can update their contact information. So 95% of the things that landlords could previously do with paper forms, they can do through the rent registry. Tenants can also use the rent registry if they like. They can request that staff review registration information submitted by their landlord if they think it's incorrect. They can have staff review their current or previous rent increases if they think that there might have been an issue. And they can file a petition to request a hearing for a downward rent adjustment. I'll go over petitions in a bit. So some definitions for the terms that I've used so far. So the annual general adjustment, or AGA, that is a percentage that landlords are allowed to raise the rent every year. It is 70% of the change in the consumer price index. It's always at least 1%, but it's never more than 5. So each year this may change as the CPI changes. We don't know what that's going to be until the government produces the CPI information, which is why it's not there's a wait period until we find out that we can calculate the AGA and let folks know. Base rent. So it's going to be one of two things. If you have a long-time tenant that's been there, let's say for 30 years, it's going to be the rent that was in effect on September 1st, 2019, which is when the rent ordinance came into effect, or the start date of tenancy if it's after that. So if you have a tenant that starts their tenancy tomorrow, that will be their base rent tomorrow. And the apparent lawful rent ceiling. This is the maximum rent a landlord is permitted to charge during the program year in compliance with the annual general adjustment and banking regulations. So banking, what is that? Well, a landlord has the option to raise the rent less than the AGA, and or maybe they just don't raise the rent for some reason, they forget, or they have things going on and they haven't raised it. That amount will be banked or saved, and they can use it in subsequent years. However, there are limitations. No increase may exceed 3% plus the annual general adjustment of that year. Banked rent increases may not be imposed in consecutive years. They cannot be imposed more than 3 times in the lifetime of a tenancy. They are not transferable to new owners. They expire at the end of a tenancy, and there's also some notice requirements, some paperwork that needs to be given to the tenant and also to the rent program when a landlord does a banked rent increase. So here on this page is an example of the annual general adjustment, the lawful rent ceiling, and some banking examples. So on this column on the left-hand side, on the far left, you'll see that it has the program years. In the middle column, it has the annual general adjustment, and then it has in the right column the lawful rent ceiling. So if the base rent is $2,000, this just shows what the rent could have been raised to under the LRC. So here's an example. If your base rent is $2,000 and the current rent is still $2,000, then we're going to assume that there's a banked amount because there has been no rent increase. So if there's an AGA rent increase, the current annual general adjustment is 2.7%. So if the landlord wanted to just do an annual general adjustment, rent increase would be $2,054. There remains $278.60 available to be used if the landlord wants to do a banked rent increase. They can do a banked rent increase of up to 5.7% because the rules allow 3% of their saved bank plus the current annual general adjustment. So that would be $2,114. There still remains $218.60 of bank that landlords could use for future bank rent increases. But again, You can only do three, and they can't be in consecutive years. Petitions. Both landlords and tenants can submit petitions to the program. Uh, Petitions are heard by hearing officers who issue binding decisions. Again, hearing officers are not city employees. They are independent um, contractors, if you will. They're independent individuals that the city contracts with because we want to make sure that the process is as fair as possible. The petitioning party has the burden of proof and may provide any documentation or evidence in support of their position. Respondents, whoever is responding to the petition, will also likewise have an opportunity to submit evidence or documentation. Either party can bring an advocate to the hearing. So that could be a lawyer, it could be an advocate of some kind, it could be a family member, it could be somebody who's going to be a witness, could be a professional that could speak to the issues that the petition brings up. Landlords can petition for an upward adjustment based on a fair rate of return, and tenants can submit a downward adjustment based on a decrease in housing services. I'll go over what those two things are right now. So, a landlord can file a petition for an upward adjustment of rent based on a fair rate of return. There's two forms that are required. One is a cover form called RP 200, and the other is an attachment A. It's a request for a fair rate of return attachment. It will ask more detailed information about the property and the landlord's finances. What is a fair rate of return? Well, the way that we use it, the rent program uses it, is it's at least a maintenance of net operating income. So if the base year net operating income, and here's an example on this page, was $20,000, and there has been a factor change in CPI since the base year of 1.2, then adjusted, the base year NOI is $24,000. And let's say this year, from the property, the landlord only made $22,000. Well, there's a difference of $2,000 between the adjusted NOI and the current NOI. So if we assume that there was a 4-unit building, then the landlord would be allowed to increase the rent $41.67 above any other rent increase in order to maintain their net operating income. This is a way, this is a mechanism in the ordinance to make sure that landlords are at least maintaining their operating income. And if for some reason the annual general adjustment is not sufficient to have to make up for those increase in landlord costs, this is a mechanism in the ordinance to address that. Here's an example of a landlord petition for a fair rate of return that does not result in an increase. So again, if the landlord during the base year, when the rent ordinance was introduced, was making $20,000 off a fourplex, there's been a factor change of 1.2, so the adjusted base year NOI is now $24,000. And let's say this year I'm the owner of that fourplex and I made $25,000. Well, I've actually increased my net operating income. So this would not result in a fair rate of return petition being accepted because I have not only maintained my net operating income, but I have increased my net operating income. Tenants can file for a petition as well, kind of the opposite. It's called a downward rent adjustment based on a reduction in services. Again, two different forms, a cover form and then an attachment called A, RP 100A, where the tenant can outline in more detail what they feel is a reduction in services. And what is a reduction or decrease in services? Well, it's the landlord has taken away or failed to continue to provide a service that used to be provided to the tenant in their rent. So an example of that would be if the lease says that a tenant can have a pet and it's included in their rent, and then the landlord says, no, you can't have a pet anymore, that would be a decrease in housing services. If there used to be a balcony and for some reason it was removed, if the tenant had a parking spot and the landlord took it away, um, or if there are other amenities or substantial deterioration of the property so that the tenant can no longer enjoy that property when they moved in, those are examples of what would be considered a decrease in housing services. So again, it's the petitioner's responsibility. They have the to show this, to prove this, they have the burden of proof. So the tenant would have to provide some kind of documentation in order for this to be considered. So those are petition types that landlords and tenants can file with the rent program. There's also something called staff review. These are a little bit different. These do not go to a hearing officer. They go right to staff, just like it sounds, because staff is going to be looking at the facts of the ordinance, and this is not something that's subjective, so staff can make a decision on this by themselves. So landlords can request a review of the apparent lawful rent ceiling if they think there's been some kind of error in calculation. Tenants can request the same a review of the same thing. They can also request a review of the base rent or housing services that have been reported by the landlord. For example, if I'm a landlord and I report to the rent program that all utilities are included in the rent, but then my tenant sees that and says, hey, actually, I pay my own electricity and my own gas, that's something they can have staff review. Tenants can also have staff review previous or pending rent increase notices to make sure that they comply with the rent ordinance. And this kind of gives the life cycle of a review of a rent increase, which is the most common staff review that we get. So if a tenant asks us to review a rent increase, then we take a look at it. If it meets all of the cities and the ordinance requirements, then there is no action taken. We'll just tell the tenant that the landlord has given a lawful rent increase and there's no action to be taken. If it's deficient in some way or incorrect, it'll fall into two camps. Either it is a future rent increase, meaning the landlord has given a notice to increase the rent, but it hasn't happened yet, in which case staff will reach out to the landlord and say, hey, you need to rescind that notice because it's incorrect, usually because it's probably too much. If it's a past increase that was incorrect, staff will tell the landlord that they need to both reset the rent to the rent before the invalid rent increase, and they'll need to refund any overpayments that had happened. Rent relocation increases. So this is really only going to apply to partially regulated units. So previously I had mentioned that there are two types of properties that are regulated: fully regulated units and then partially regulated units. Partially regulated units, again, they are not subject to rent control, but they are subject to termination of tenancy rules. So when a tenant in a partially regulated unit receives a rent increase that is 10%, or I beg your pardon, that is above 10%, and the tenant chooses to vacate within 90 days of receiving that notice, they are owed permanent relocation payments. And if the landlord notices to increase the rent above 10%, they need to provide Form RP 209 to the tenant when serving that notice. And within 3 days of noticing the tenant, they need to provide a copy of that to the rent program, the notice plus RP 204. The city's rent ordinance it's treating that very large rent increase almost like a termination of tenancy. So if a landlord wants to give a rent increase above 10% and the tenant moves out in a partially regulated unit, the tenant is entitled to permanent relocation payments.
Thank you, Brendan. My name is Ryan Helper, and I'm a analyst with the Alameda Rent Program. And I'm going to be talking about capital improvement plans and terminations of tenancy in the second half of this presentation. So the purpose of capital improvement plans is to encourage landlords to improve the quality of the city's rental housing stock. The costs of these improvements are passed to tenants over long periods of time, what we call amortization. Um, there are some protections for tenants who are displaced temporarily. Um, Now, the qualifications are that only certain types of long-term improvements qualify for this pass-through. And the list of qualifying improvements, the short version of it, a new roof, a upgraded foundation, including seismic retrofits, significant plumbing projects, electrical or HVAC, and at least one or more rental units. Exterior painting or installation and replacement of siding, it has to be a substantial project. It can't just be repairs, dry rot repairs to one side of the house. It has to be a substantial, like siding repainting project for the entire home, or the entire rental property. Uh, Addressing a wood destroying pest report, termites, um, installation of water conservation devices, energy saving improvements, including work to allow from the conversion of gas to electric utilities and appliances, installing fire suppression and fire safety systems, earthquake shutoff valves, stair and railing improvements. It needs to be significant, like a new stairwell and not just repairing the handrails. Lead paint remediation as well qualifies. And please note that the qualifying capital improvement project must be at least $10,000 for a multi-unit rental property. Now, what doesn't qualify are what we call routine repairs, such as replacing broken windows, interior painting, um, also any additional cost incurred for deterioration due to the unreasonable delay of completing the repairs. Um, and also things that don't qualify would be improvements or repairs for which the landlord received insurance proceeds or a grant. So it would have to be something that the landlord does have to pay out of pocket that we can then um, calculate a pass through to the tenants in addition to the allowable AGA and bank rent increases. So next slide here. The city adopted a new capital improvement plan policy just last December. So this was the first full calendar year, 2024, that we had this newer policy. Um, and so the most significant difference between this version and the old policy is that larger properties with 25 or more units aren't eligible to do capital improvement plan pass-throughs to the tenant. They are still eligible to do those fair return petitions that Brendan was talking about earlier, in which capital improvement expenses can be included as net operating expenses versus net operating income. Uh, the so then as it kind of there's a scale here. The smaller properties, 2 to 4 units, 100% of the cost of these improvement projects can be passed through to tenants. Um, if it's 5 to 15 units, it's 75%. 16 to 24 unit properties can do 50% of the total costs. So there is a cap now on the total amount of pass-through. Um, so the way we calculate a pass-through is we look at the total cost of the project. We divide that by the number of rental units at the property, and then divide that number by the what we call the amortization period, which is generally 15 years of useful life or 180 months is our kind of benchmark amortization. And so that's how we can figure out what the CIP pass-through would be. Then we have to go and make sure that it's not going to be more than 5% of the tenant's current rent. And it can, if it's combined with a AGA or bank rent increase, it can't be more than 8% of the tenant's current rent. Again, so there's that minimum threshold. The project has to be at least $10,000. Um, and if it's more than 10 units on the property, it's got to be at least 1,000 per unit. So there is also in this new version of the policy, a tenant hardship exemption. So if a landlord is approved for a CIP pass-through, tenants may be eligible for a hardship exemption, based on their income. They did add in the new policy some different types of projects that weren't in the original eligibility lists, energy efficient conversions, fire sprinkler alarm system, earthquake shutoff valves, seismic retrofits, replacement of stairs or railings. And also, one major difference between the previous policy is landlords used to be able to do a permanent relocation based on capital improvement plan projects. Now that is no longer allowed. A tenancy cannot be terminated because of a capital improvement project. The landlord and tenant have to agree to a temporary relocation situation. So, going to talk about terminations of tenancy now. The ordinance lists 8 grounds um, that must be identified whenever a tenancy is being terminated. Now, the first 4 grounds here are not something that the rent program administers. These landlords and tenants are advised to review state law and speak to a legal service provider if it's for one of these 4 cause grounds: failure to pay rent, breach of the rental agreement, nuisance to the property, and failure to give access to the landlord or property manager. Now, where the rent program does get involved and what we do administer are what are called no fault grounds of termination of tenancy. So this would be something that for no fault of the tenant, their lease, the rental agreement is being terminated. So this would be a case of an owner move-in, if there's demolition of the property, withdrawal of the rental unit from the rental market, also known as the Ellis Act, and compliance with a government order. And again, I also want to emphasize that the ordinance does point this out. We get a lot of questions about this. The expiration of the term of a lease is not grounds for terminating the tenancy. So if a tenant moves in, they sign a 12-month lease, they don't want to sign another 12-month lease, they just want to stay month to month. A landlord cannot terminate the tenancy just on the grounds that the lease term expired. So in the termination process here, there's kind of 5 steps to consider. Again, identifying one of the allowable grounds, one of those 8 grounds. If it is one of the no fault grounds, the rent program requires you to file a copy of serving the notice to the tenant and verify that the relocation payment is going to the tenant. And in situations of the owner move-in or an Ellis Act termination, there's going to be restrictions concerning the rent or occupancy of that unit moving forward. So for an owner move-in, the owner must have 50% ownership and be a natural person. It couldn't be owned by an LLC. The person moving in must be the owner or a qualifying relative. Generally, qualifying relative is immediate family. The person moving into the unit must move in within 60 days and occupy that unit as a primary residence for 3 years. And so termination for this can only be used once every 24 months, and the property cannot have a comparable vacant unit available. When we're talking about comparable units, this does come up also in temporary relocation cases. It's another unit on the property that would have similar square footage, same number of bedrooms, and similar amenities. If the tenant is disabled, the comparable unit must be disability accessible and ADA compliant. If the comparable unit is not currently habitable, but the unit could be made habitable without requiring a building permit, the landlord cannot terminate the tenancy. In the case of a demolition to the property, we do need to verify that the landlord has city-approved permits for demolishing the property, and then we're going to verify that the tenant's receiving that permanent relocation payment. And so with the Ellis Act, the major difference between the Ellis Act and the OMI provisions is that a landlord must certify an intention to permanently withdraw all accommodations on the same parcel of land. So in the case of an OMI, if it's a 4-unit property, a landlord wants to occupy one of the 4 units, they can use the OMI provision. But if they're going to do the Ellis Act provision, if it's a 4-unit property, they would have to terminate all 4 tenancies and certify that they've withdrawn the property from the rental market. Compliance with a government order would, of course, be a situation where code enforcement is involved. It could be a government entity. 99% of the time, we're talking about City of Alameda code enforcement. They've issued a notice to vacate. It's not a habitable unit. It's not going to be reasonable for the tenant to return. In the near future, the landlord could use this notice if the tenant wants to move out permanently and find new housing uh, to pay relocation payments based on that notice from code enforcement. So when a landlord serves the notice to the tenant, the grounds for termination must be listed, of course. Notices on owner move-in must also state the name of the person moving in and the relationship of that person to the owner. The notice must comply with state law noticing requirements. Generally, if we're talking 60 days. Um, the withdrawal of the rental market have additional requirements, and that noticing period is 120 days, 4 months, which I'll explain too. There's also an option for a tenant to stay, request the right to stay longer than the 120 days. And then, of course, this notice must have the exact amount of relocation payment to be paid. We'll have a slide coming up on relocation payments shortly. Then again, within 3 calendar days, landlord has to file a copy of this with the rent program. RP 201 is a termination cover letter or cover template landlords use, and then a copy of the actual termination notice needs to be uh, um, filed with the rent program. And when we're talking about supportive documentation, we ask for beyond sometimes just a termination notice. This generally comes up in these OMI, owner move-in cases, when we're talking about things that substantiate qualifications for the owner, that they have at least 50% of the ownership of the property, which is a requirement, and that they are a natural person. Sometimes it gets a little confusing with trusts and who's in the trust and what's the relationship of the person moving in to the trust. So what we're talking about, something like grant deeds, tax documents, and then driver's license, proof of ID, um, trust supplying us with, yeah, trust documentation as well. We'll sometimes ask for that in these OMI, owner moving cases. Now, for the Ellis Act cases, the withdrawal of the rental unit from the rental market, there's quite a bit more forms. There's that 120-day noticing period for the tenants. Tenant has a form they can complete to assert a vacate date. If they qualify, meaning if anyone in that resident, that tenant household is over the age of 62, if there's anyone under the age of, if there's any children under the age of 18, or if anyone has a verifiable disability, they can request to assert a vacate date of up to 1 year from the notice. The landlord has to provide a proof of service and get a recordable memorandum notarized uh, for us to send to the county clerk. So whenever a landlord files a termination with us or a tenant requests a review of a notice, they're not sure if it's a termination notice or not. We'll review it to determine if it meets the city requirements, and we'll send a letter to verify these are the relocation payment amounts and if there's going to be a restriction to the rent or occupancy moving forward. Of course, if we find it's a deficient notice in violation of the rent ordinance, a letter will be promptly issued to the landlord asking them to rescind that notice. Now, relocation payments, how these are filed, these are based on HUD's fair market rent estimates for the East Bay, Oakland, Fremont metro area. Moving expenses are considered, and other factors such as taxes. The idea is to cover, right, a tenant has to move out, first month's rent, security deposit, and some moving expenses. There are some enhanced benefits for what are called qualified tenant households. Those are any households that have one of these three. It can be any one of these three: seniors, person with a verifiable disability, and any children younger than 18 in the household. These are the current amounts. These get updated every year in July based on the change in consumer price index. But there you can see the base amount for a studio 6430 all the way up to a 4+ bedroom unit, 12,000. Now that qualified tenant household figures on the right side there, those are the households, remember, that have a senior or someone with a disability and or any children under the age of 18. They would get that qualified tenant household amount. And so the way these are divided up, it's based on the bedroom size of the rental unit and not how many people are in the household. So if there's one person in a 3 bedroom, they get that full 10,476. If it's 3 people splitting a 1 bedroom, they would have to split up that $7,222 3 ways. And again, these get updated every year in July. So the first half of that relocation payment's owed within 3 business days after the tenant has informed the landlord in writing when they're going to vacate the rental unit. Um, and of course, their intended date to move must be no later than the date of the termination notice. Um, the second half of that relocation payment's owed after the tenant has vacated the rental unit and removed all of their personal property, including storage from the property. Um, and the tenant must vacate no later than 2 calendar days after the date that was in the termination notice. So if the tenant doesn't vacate on day 60 and they don't they don't vacate by day 62, the rent program can no longer enforce that second half of the payment because the tenant did not comply with the rent ordinance by vacating within those 60 days, 62. So when there are restrictions on a unit following a termination, so again, for OMI cases, the owner moving, the person that's moving into the unit has to reside there as their primary residence for 3 years. What the rent program does is called annual monitoring, where we will ask the person that's moving into that unit to verify they're still using it as a primary residence. Um, and if they're going to try to return it to the rental market, uh, the restriction would be the rent cannot be increased more than 5% above what the previous tenant was paying. So again, that restriction only applies for those first 3 years. If it's a Ellis Act case, withdrawal from the rental market, um, it can't be rented for 5 years unless the displaced tenant gets the right of first refusal. If they do return those units to the rental market, the rents cannot be more than 5% above the rent at the time of termination. So there's those extra provisions there. So there's no kind of way to skate around the rent control by terminating a tenancy using the Ellis Act. That's why there's still going to be that rent cap for 5 years. And again, this is related to the Ellis Act cases, that extended stay option. Um, as long as the tenants live there for more than 1 year, they are 62 years of age or older or have a disability, they have the right to request that extended stay option for 1 year before they have to find a new place to live. They, of course, do have to continue to pay rent each month, like before. So buyout agreements are a little bit different than terminations of tenancy. What these are kind of a voluntary written agreement between landlords and tenants by which the tenant agrees to vacate on a certain date in return for compensation. So the rent ordinance does require that landlords serve a form RP 205, which kind of lays out the tenant's rights under the rent ordinance, which include not to enter into the agreement if they don't, they would prefer not to do a buyout agreement. They have a right to consult an attorney. They can consult the rent program for information, but we can't give legal advice. We can only confirm, uh, you know, regulations regarding buyout agreements. Um, if anybody wants to request, specific amounts of buyout agreements to get filed with us, they would have to submit a public records request with the city of Alameda. We do publish each year in our annual report the total amount of buyout agreements that are filed and the average buyout agreement compensation. But if somebody wants more specific information than that, they would have to submit a public records request. Uh, And so again, landlords must file a copy of the signed RP 205 and a copy of the actual buyout agreement with the rent program within 3 calendar days. Temporary relocation payments. These are required when a tenant has temporarily vacated unit in compliance with the government agency's order due to the health and safety conditions. The definition of health and safety conditions, some of this comes from state law that's been adopted into the city ordinance. These would be conditions in the rental unit resulting from, among other events, flooding, fire, or smoke, lack of proper maintenance, or facilities failures not caused by a tenant. That in the determination of a government agency or a court of competent jurisdiction have an adverse effect on the health or safety of the tenant, which has rendered the rental unit uninhabitable. And as to rental units in the Housing Choice Voucher Section 8 program, if they fail that what's called the HQS Housing Quality Standards inspection, those tenants would also qualify for what's called temporary relocation payments. Um, and so, as with permanent relocation payments, generally there's an exception for natural disasters in most cases where the landlord has not contributed to conditions causing the displacement. But again, that every case is different, so there's a big asterisk on that. But this comes up a lot when there was flooding a couple winters ago when we had a ton of rain. Um, we had to look at more information than just the code enforcement determination to see if it was attributable to the landlord's neglect versus the tenant's actions. But in most cases, will depend on the code enforcement's determination that the unit's not habitable. Um, so again, there's landlord can offer a comparable unit. If there's a vacant comparable unit at the property, they don't have to pay temporary relocation payments. There's a form RP 207 that needs to be filled out and then filed with the rent program along with the proof of service within 3 days of when the tenant has to temporarily vacate due to the health and safety conditions. So the way temporary relocation works is designed to the theory, right, is to help a tenant pay for, a hotel short-term rental while the repairs are being done to their unit because they would like to remain, in their original home. So these are per diem basis, and these are calculated, yeah, again, per diem per day, but they must be paid in weekly installments. Now, during this time, the tenant is also paying rent still because they want to remain in their original rental unit. They just need help covering the costs of temporary lodging. Um, so as you can see, if you look at the average hotel or motel price in Alameda, um, meal expenses per day per person, these can get quite expensive, right? These per diem. So, uh, yeah, these large, the city recognizes that these numbers can tally up to large amounts really quickly. The thinking behind that is to make sure that the tenants get back into their unit quickly and the problem is taken care of in a timely fashion so that they can return. Now, these temporary relocation per diem payments, these only are the first 60 days of displacement. So if it's going to take more than 2 months for the repairs to be completed, then we move on to something called rent differential. So this would be a situation where the tenant, maybe they signed a short-term lease somewhere else, but they still maintain that they want to move into their rental unit. If it takes more than 2 months for repairs to get done, the landlord would have to figure out, we have to look at the difference between what fair market rent is for that unit, um, and what the current rent was at their unit that they still want to move back in. So for example, they're staying in a studio apartment, they're paying $1,000 a month. There's a code enforcement habitability issue. They have to vacate. They're gone for 2 months. They're staying in a short-term rental. Um, the landlord would have to pay the tenant the difference between what they're paying before, that $1,000, and the fair market rent for a studio. So the landlord has to contribute $567 a month to this tenant. Tenant doesn't pay rent anymore at this point past those 60 days. But again, the goal is to try to move back into their original rental unit. And so if it takes more than 2 months, then we move to this rent differential period. In most cases, if it takes more than 2 months for the repairs to get done, the tenant will elect to do permanent housing and just sign a new lease somewhere else. In that case, the landlord also has to pay them those permanent relocation payments that we discussed a few slides before. So there are situations where a landlord has to pay temporary relocation, rent differential, and then permanent relocation to a tenant. So something else that's a unique thing within our rent ordinance is what's called temporary tenancies. So we've talked about all these relocation payments, right? Permanent relocation payments. If a landlord and a tenant agree beforehand, that this is going to be a temporary living arrangement, it would have to be at the landlord's primary residence. So it would have most times, designed for like a single family home that's partially regulated, or it could be an owner occupied unit in a fourplex. But it has to be the landlord's primary residence. It can't exceed 12 months. It can be up to 5 years if it's a connection with a military assignment. But the idea here, right, is at the start of the tenancy, both the landlord and tenant agree this is a temporary tenancy, and that when the tenant moves out, before those 12 months, the there would be no relocation payment because everybody agreed beforehand this was just a temporary arrangement. A landlord must file at the start of the tenancy a copy of his temporary tenancy rental agreement, and then they are required to move back in as their primary residence for 1 year. So we're going to ask the landlord to verify, hey, after you did this temporary tenancy with this tenant, did you move back in within 60 days? And are you going to stay there for at least a year? So if any landlords listening are bringing in new tenants, just signing a new rental agreement with the tenant, um, they're required to provide the tenant with this notice we have available on our website, RP 208. Basically lets the tenant know that their unit is subject to the rent ordinance. Um, if the tenant wants to request a copy of the rent ordinance, the form has links for them where to find this information online. And if they would like to request a paper copy, they can do so. We also encourage landlords to give a copy of our information brochure. We have those available in our lobby, and we also, if anybody wants us to mail some of those brochures to them, we can do so. There's a printable PDF version on the website. If you have a printer, then you can figure out how to fold it correctly. But we have plenty of these brochures available over at City Hall West. And then just another reminder too, the rent ordinance requires landlords to register new tenancies within 30 calendar days. Another thing to take note of, the rent ordinance does have retaliation protections. Landlords are prohibited from retaliating against tenants for asserting their rights. So examples of retaliation may include termination of the tenancy, increasing the rent, reducing the tenant's housing services, neglecting repairs and maintenance requests. So any tenant or landlord that has a retaliation issue can file a complaint with the city attorney's office, and one of the investigators will review the case. So one of the most common questions we get, of course, is rental property sales. How does that work? Um, so an owner must disclose to any buyer and buyers that a unit is subject to the rent ordinance, including any restriction caused by a termination of tenancy. For example, there might be a rent restriction on the unit. The current seller has to disclose that information to the buyer so they're aware there's a rent restriction related to a termination of tenancy. And the new owner may be held financially responsible for a prior owner's violation of the ordinance. So if the previous owner never paid the rent program fees, um, if there were invalid rent increases that were not rectified, that now falls onto the new owner uh, to assume that responsibility. So any potential purchasers should contact the rent program concerning restrictions on renting the property and if there have been any recent violations or compliance concerns regarding the property. All right, this is our contact information. We are at City Hall West, 5 days a week. You can call us at any time and leave a voice message after business hours. Um, Email us anytime at that email address. And we have plenty of available resources on our website, alamedarentprogram.org. And thank you all for attending tonight. I'm going to stop the recording.